Within just the past year, our firm has handled multiple hearings before the Trademark Trial and Appeal Board, both in person and over video. And over the years, we have handled many dozens of hearings before the board. I get asked by people a lot because of my experience with hearings for some key tips in preparing for a hearing. And I want to share the top tips with you today. First, you got to know the rules in the Trademark Trial and Appeal Board. The rules for evidence, the rules for the case, and the rules for the hearing. Yes, they're very similar to the federal rules of civil procedure, but they have their own nuances and difference, and it's important to know what they are. Next tip, you must know the evidence of record in the case. And generally, I would always prepare for the hearing by making a binder full of all the evidence in the case. As much as I hate to print on paper, it's one of the rare times I still do. And then when I'm at the hearing, I have the entire binder organized and tabbed with me so that if I need to refer to specific evidence in the record, I can, and I can show the judges that that evidence is tangibly in the record. Because saying there's evidence about a particular fact is one thing. Knowing there's evidence is better. And then knowing there's evidence and pointing directly to the page number of that evidence is far and away the best and most convincing way to talk about a fact and evidence. Next tip is to do the hearing standing up. Now that so many things are on Zoom or video, I've noticed that people have a tendency to sit at their desk. Maybe they don't have a setup with a standing desk or that allows for standing. I strongly recommend investing in one. If you're watching this episode on video, you'll notice that I move around a little bit because I am standing up when I record these videos. It's much better energy. It's much better eye level and focus for the camera. And it's just makes your performance literally thinking on your feet that much better. When people are sitting, I notice, because I watch a lot of other hearings, I notice they tend to slouch. They tend to look down at their materials. They tend to have lower energy. I'm telling you, standing up is a simple but key tip. And finally, people ask me, when should we request a hearing? What type of case is it valuable to have a hearing or not? And that's difficult. Every case is unique, but I would say request a hearing when you have something important to say. Maybe it's something important about the evidence that's hard to explain in the brief. Maybe it's something important about the story of the party and the history of the case. Maybe it's something important about the law that's a new issue that's never been examined or decided before. When you have something to say, in my opinion, it's worth doing a hearing. I've really never regretted having a hearing. I feel like it can only strengthen your advocacy for the client before the TTAB. So those are my tips for a TTAB hearing. If you have questions about a TTAB case or anything trademark related, you can always reach out to me. Find the Connect with Us button on the top right at ericpelton.com.